€485 a month. Then after one renovation, €1,199 a month. Same apartment, same building, same city, with some of the strictest tenant protection laws in Europe. The tenants took their landlord to court over it. They lost. Not because the judge sided with the landlord out of sympathy, but because what the landlord did was, and still is, completely legal. Germany has some of the strongest rent control on paper of any major economy. And yet, almost exactly 5 years ago, lawmakers had to rewrite the rules because landlords kept finding completely legal ways around almost all of it. They tightened one loophole in 2019, and landlords simply leaned harder on a second one that was already sitting right there in the law. This is how both of them work, why they exist, and what they actually mean for anyone renting in this city today. The first mechanism is called the Modernisierungsumlage, the modernization surcharge. Under German law, if a landlord renovates a building, new windows, insulation, a new heating system, they're allowed to add a percentage of the renovation cost per apartment onto the annual rent, permanently, not temporarily, not until the cost is paid back, permanently for as long as the tenant stays. And here's the part that makes it so powerful. This surcharge doesn't need the tenant's consent, and it isn't limited by the Mietspiegel, the local rent index that caps almost every other kind of increase in Germany. Before 2019, landlords could add 11% of renovation costs to the rent every year, with no upper limit at all. Cases like that became infamous in Berlin. One landlord portfolio sent modernization notices that would have pushed one tenant's warm rent from €680 to roughly €1,600 a month, and another tenant's from €700 to €2,000 for an apartment that still had an outdoor toilet. Stories like these are exactly what pushed lawmakers to reform the rule in 2019, almost exactly 5 years before this video. Since 2019, the surcharge dropped to 8%, and a new cap was added. Rent can't rise by more than €3 per square meter over 6 years because of modernization, or just €2 per square meter if the starting rent was below €7. That sounds like real protection, and it is compared to before. But look at what it still allows. For a 70 square meter apartment, that's still up to €210 a month, permanently, on top of whatever regular rent increases already apply. Stacked, not instead of them. And once the landlord has recovered their renovation cost, which the math works out to about 12.5 years, at 8% a year, the rent doesn't go back down. Ever. The first loophole works on tenants who are already living in the apartment. The second one works the moment a tenant moves out, and it's arguably more powerful because it doesn't just raise the rent. It removes rent control entirely. This is the one landlords leaned on harder once the first loophole got tightened in 2019. Berlin has a rule called the Mietpreisbremse, the rent break. In theory, when a new tenant signs a lease, the rent can't be more than 10% above the local comparison rent. But there's an exemption written directly into the law. It doesn't apply to apartments that have been comprehensively modernized, and the legal bar for that label is lower than you'd think. Roughly speaking, if a landlord spends about a third of what a comparable new build would cost, new floors, new electrical wiring, a new bathroom, a new kitchen, the renovated apartment is treated legally almost like new construction. And new construction isn't bound by the rent break at all. That's exactly what happened in a Berlin case that went all the way to court. A landlord renovated an 86 square meter, 3-room apartment for just under €60,000. New floors throughout, rewired electrics, a modern bathroom, a renovated kitchen with built-in appliances. The previous tenant had paid €485 a month, net cold. After the renovation, the new listed rent was €1,199, nearly 2.5 times higher. The new tenants challenged it, arguing the rent break should still apply. The court disagreed. Because the renovation met the legal bar for comprehensive, the apartment was treated as functionally equivalent to new construction, and the Mietpreisbremse simply didn't apply. That's the headline of this entire video, in one sentence. A landlord legally more than doubled the rent on an existing apartment. A court reviewed it and confirmed it was completely within the law. And this isn't settled history. The legal boundary is still shifting recently. In April 2025, the Berlin Administrative Court ruled that even in Milieuschutz zones, areas specifically protected against tenant displacement, landlords are allowed to install things like wall-mounted toilets, heated towel rails, and small balconies, because these no longer count as luxury. They count as standard. The district office had tried to block those renovations specifically because they worried about displacement. The court sided with the landlords. Here's why this matters beyond one court case. According to Berlin's Investitionsbank, the median asking rent for new listings across the city reached roughly 15.74 euros per square meter in 2025. And that's the rent new tenants face after the kind of renovations we just walked through. Meanwhile, a 2025 study from the German Institute for Economic Research found that in Berlin's protected Milieuschutz neighborhoods specifically, household rent burdens regularly exceed 30% of net income, the exact threshold courts have historically used to define financial hardship. None of this is fraud. None of it is a landlord breaking the rules. Every mechanism in this video exists because lawmakers wrote it into the law, on purpose, usually with a legitimate goal attached, encouraging energy-efficient renovation, allowing landlords to recover real investment costs, not freezing the housing stock in 1980s condition forever. The problem isn't that any single rule is unreasonable. It's that stacked together over a span of about 5 years, they created a path where a tenant on a stable local income can be priced out of an apartment they've lived in for years, entirely within the law, with a court confirming it every step of the way. Every city eventually has to answer the same question. How do you let landlords recover the real cost of keeping buildings livable without quietly legalizing the displacement of the people already living in them? Berlin's current answer is somewhere in between, better than it was before 2019, but still wide enough for a court to confirm a 147% rent increase as entirely lawful. If your city hasn't faced this question yet, it probably will. I'm curious, has something like this happened where you live? Tell me in the comments, and I'll see you in the next one.